Tantor Audio, a division of Recorded Books, presents The End of Roe v. Wade, Inside the Right's Plan to Destroy Legal Abortion, by Robin Marty and Jessica Mason Pieklo. Narrated by Joanna Perrin. Introduction. The day the end began. On June 27, 2018, there was no indication that the abortion rights landscape was about to undergo a seismic shift to the right. That morning, the Supreme Court was finishing up another contentious term, releasing a decision undercutting the power of public sector unions to collect dues and using the First Amendment to justify its decision. Just the day before, the conservatives on the court had upheld President Donald Trump's Muslim travel ban, and earlier in the month had punted on resolving a case involving a Colorado baker who had refused to bake a cake for a same-sex couple because of a religious objection to marriage equality. But with no abortion rights cases on the court's docket for the following term, and still feeling optimistic about the previous year's abortion rights win in Whole Women's Health v. Hellerstedt, pro-choice advocates turned their attention to challenging a fresh new wave of anti-abortion measures in the states. The ascendancy of Donald Trump and Mike Pence to the presidency in 2016 had emboldened the religious right, who saw this as their moment to realize over 40 years of grassroots and institutional advocacy to overturn Roe v. Wade. Yet, as the court's term came to a close that early summer day, anti-abortion forces didn't realize just how close they were to achieving their dream. After the court finished its business, the reports started coming in. Supreme Court Justice Anthony Kennedy, the court's swing vote, and the justice widely believed to be the key vote to keeping Roe on the books, was retiring. President Trump, who had campaigned on a promise of only appointing Supreme Court justices intent on overturning Roe, would get to name Kennedy's replacement. And just like that, the pendulum on abortion rights had swung back sharply in the anti-abortion movement's favor. Liberty finds no refuge in a jurisprudence of doubt, wrote Justice Sandra Day O'Connor in the opening of Planned Parenthood v. Casey, the 1992 abortion rights decision that would both reaffirm Roe's holding that the right to an abortion is fundamental and also adopt the undue burden standard for judging future abortion restrictions. The woman's liberty is not so unlimited, however, that from the outset the state cannot show concern for the life of the unborn, and at a later point in the fetal development, the state's interest in life has sufficient force so that the right of the woman to terminate the pregnancy can be restricted. O'Connor's opinion in Casey continued. The undue burden formula in Casey shifted the court's intellectual framework away from considering abortion to be a fundamental right upon which the state should carefully intrude, to abortion as a right that existed only in relation to the power of the state to regulate it. Justice Anthony Kennedy was only in his fourth year on the court when Casey was decided. A centrist from California, Kennedy had been appointed by President Ronald Reagan to replace the retired Justice Lewis F. Powell, Jr. Kennedy wasn't Reagan's first choice. Former Nixon Solicitor General and culture warrior Robert Bork was the president's initial pick. Reagan, a conservative Republican, was a staunch opponent of abortion rights, and his rise to the presidency opened a new era of political power for social conservatives. But it was Bork's fierce public opposition to abortion rights and civil rights that would doom his nomination and ultimately put Kennedy on the bench. Had Bork been confirmed, it is very likely that Casey would have been decided the other way, with Roe possibly being overturned within 20 years of having been decided in 1973. But instead it was Justice Kennedy joining O'Connor to save Roe v. Wade, and abortion rights supporters breathed a sigh of relief, at least for a little while. If O'Connor had hoped her opinion in Casey would end the question of whether or not Roe was settled law, that hope could not have lasted long. Casey's undue burden framework gave anti-abortion advocates a new opening in their war on choice. Individual states were now free to test the limits of what constituted an undue burden on abortion rights. And test the limits they have. In the last decade, states controlled by Republican lawmakers have become laboratories to cook up the most restrictive, yet constitutionally acceptable limitations on abortion rights under Casey. States that were once without mandatory waiting periods saw bills mandating a 24-hour waiting period between a consultation with a doctor and the actual termination of a pregnancy. Those that already had one-day waiting periods saw that period extended to 3 days. States that allowed minors to obtain abortions without involving their parents were now ordering girls to notify their parents in advance, while those that already had parental notification laws in place were now proposing parental consent, sometimes from both parents, as well as limiting the ability to obtain a judicial bypass. Dozens of states have made getting an ultrasound, as well as listening to a government-sponsored script describing the image and warning about the possibility of depression, suicide, breast cancer, and other medically disproven side effects of abortion, a prerequisite to termination. Others forbid abortion prior to viability of the fetus, even if the fetus has a terminal condition or the patient's health is at risk. States are placing more and more limitations on medications used to cause an abortion. In at least 5 states, access has whittled down to a single clinic. This and more have been the end result of a right-wing campaign that began the day Roe v. Wade was decided in January 1973. And with the election of Donald Trump, the retirement of Justice Anthony Kennedy, and Brett Kavanaugh's ascension to replace him, this campaign is now about to bring us to the end of Roe v. Wade. 1. Where it all started. Nebraska. The Good Life. Since the 1970s, a sign proclaiming the good life welcomes you into Nebraska, a land of cornfields, the College World Series, and an unwavering belief by many of its residents that just as there is no contradiction in being a registered Democrat who hasn't voted against a Republican candidate in decades, there's also no contradiction in believing the government's interference should be outlawed in every instance except when it comes to a person's right to choose to end a pregnancy. So when State Senator Danielle Conrad stood in the front of the state's unicameral legislature in Lincoln, Nebraska, in March 2010, she no doubt knew she was already the champion of a lost cause. The Pain-Capable Unborn Child Protection Act, a new and unprecedented piece of legislation introduced by Nebraska Senator and Speaker of the Legislature Mike Flood, and extensively advocated for by Nebraska Right to Life, the state's powerful anti-abortion lobbying group, had already been sponsored by 22 members of the legislature, nearly half of its 49 senators. Even if she couldn't defeat the bill, Conrad wanted to at least expose the medical fallacies, distortions, and legal issues residing in its language, as well as its intent to try to end abortion under the guise of saving babies from excruciating pain. It was important to create a legal record, Conrad said, explaining why she put so much effort into countering the bill. If Nebraska Right to Life supports a bill, it is going to become law. But it needed to be shown that there was not unanimous consent, that the evidence presented wasn't undisputed, and the variety of issues that weren't being taken into account when the law was crafted. In many ways, Nebraska was an obvious choice to fire the opening shot in the battle to overturn Roe v. Wade, as the state offered several major advantages when it came to testing a piece of model anti-abortion legislation before it got fed to other restriction-friendly states across the country. First, due to Nebraska's unicameral legislature, the Pain-Capable Unborn Child Protection Act would only require one body to vote it through, eliminating the potential for it to be derailed by critics or watered down with amendments in a compromise between the House and Senate. Also, the smaller number of lawmakers to woo, many of whom already opposed abortion in nearly every circumstance, made passage of the bill certain, something the Right to Life activists needed in order to build their momentum as they began their push to challenge Roe. The hearings on the bill would provide them a platform to debate their talking points on a fetus's alleged ability to feel pain, their justification for why Roe v. Wade should be reviewed and reconsidered. Furthermore, there was the added bonus of potentially eliminating the practice of Dr. Leroy Carhart. A long-term provider of abortions in Nebraska, Carhart became the sole practitioner to openly perform later-term abortions in the Midwest after the 2009 murder of Dr. George Tiller in Kansas, a thorn in the side of anti-abortion activists in the Cornhusker State since the late 1980s. Carhart had fought vehemently against restrictions meant to undermine a pregnant person's ability to access an abortion, including parental notification laws and bans on certain types of later-term abortion procedures. Anti-abortion forces had been trying for years to get Carhart to close up shop. On the day that a parental notification law was passed in 1991, for example, Carhart was the victim of a mysterious fire at his farm, killing many of his horses and a few house pets. While the fire department said it could not determine the cause of the blaze, a letter Carhart received the following day at his clinic took credit for the fire and blamed it on his performing abortions. It was that act of violence that turned Carhart from a doctor who provided abortions into an unapologetic activist. In 2000, Carhart filed his first lawsuit to try and halt Nebraska's attempts to restrict abortion, suing the state for outlawing a type of procedure used primarily in later-term abortions. Dubbed partial birth abortion by abortion foes, the term referred to an intact D&D, but was vague enough to potentially criminalize any type of dilation and extraction, D&E, abortion, a type of abortion performed usually once the patient is 14 weeks or beyond. In an additional affront to the right to choose, the bill also took a direct and determined swing at Roe v. Wade by not allowing an exception for the health of the pregnant person. The reason, according to the state legislature, was that there is no such thing as a medically necessary abortion. Carhart brought suit against Don Stenberg, who was then the Republican Attorney General of Nebraska, challenging the partial birth ban on several fronts, including the lack of a health exception. Carhart argued that without such an exception, the law failed even the lowered undue burden standard for permissible abortion restrictions, first articulated in a dissenting opinion by Justice Sandra Day O'Connor in Akron v. Akron Center for Reproductive Health, and later adopted in Planned Parenthood v. Casey. Those cases ruled that states were allowed to put reasonable restrictions on pre-viability abortions as long as they did not place extreme hardship on patients trying to obtain them. Carhart's challenge was successful in federal district court, as well as in an appeal filed in the Eighth Circuit Court of Appeals. When the Supreme Court agreed to review the lower court decisions, it represented one of the first true tests of the Casey undue burden standard, as well as an opportunity to survey the cultural shift in the High Court away from viewing abortion access as a component of a pregnant person's liberty and toward protecting the liberty of potential fetal life. Justice Stephen Breyer delivered the majority decision in Stenberg v. Carhart, striking down the Nebraska law. But it ultimately turned out not to be the victory pro-choice advocates had hoped for, as the decision established a legal standard that would later be leveraged by conservatives to chip away at the ability to access abortion care. Citing Casey, Breyer wrote that any abortion law that imposed an undue burden on the right to choose was unconstitutional, and that in this case the Nebraska law failed because it caused those who sought or procured abortion to fear prosecution, conviction, and imprisonment. Though it was not apparent at the time, the focus of the court's analysis had permanently shifted, as no longer would it first consider the individual liberty rights of a patient. Instead, it would assume a legitimate state interest in protecting fetal rights, then balance the pregnant person's rights against that. Those who were carrying the pregnancy had officially become the secondary consideration in the restrictions on abortion access. Justices Ruth Bader Ginsburg and Sandra Day O'Connor each wrote concurring opinions. Ginsburg's concurrence stated unequivocally that the state could not force physicians to use procedures other than those they felt were safe, based on their own judgment and training. Importantly, she tied this prohibition on state action to the individual life and liberty protection under the Constitution. It was an analytical framework Breyer had either accidentally or intentionally disregarded in his majority opinion. Justice O'Connor agreed with Ginsburg's concurrence and reinforced that any law that sought to regulate out of existence a particular medical procedure would have to be applied only to prevent unnecessary partial birth abortions and would have to include an exception for the health of the pregnant person. Since the Nebraska law did not, O'Connor said it could not stand. Justice Anthony Kennedy wrote the court's dissenting opinion, arguing that the Nebraska ban was permitted under Casey and that the state had a legitimate interest in protecting prenatal life. Because the state of Nebraska had concluded that partial birth abortions were never medically necessary, Kennedy argued there could be no undue burden on a person's right to choose, since no one would ever be in a position to choose this procedure in an emergency. The rest of the conservative wing of the court added predictably blistering dissents. Justice Antonin Scalia even referred back to his earlier dissent in the Casey ruling, calling the standard unprincipled in its origin and doubtful in its application. Scalia wrote that he believed not only this case, but also Casey, and by implication Roe, should be overturned, suggesting that undue burden was so broad as to allow pro-choice activists to claim any regulation of abortion would be burdensome, making states unable to hyper-regulate abortion. It was an argument that turned both logic and decades of constitutional jurisprudence on its head. While the court ultimately struck down the Nebraska partial birth ban by a 5-4 majority, the victory for pro-choice advocates would be short-lived. Over the next 10 years, a more conservative Supreme Court, an entirely different Department of Justice, and a repudiation of decades of legal precedent would reveal just how tenuous the basic protections of Roe had become. In November 2003, Republican President George W. Bush signed into law the Federal Partial Birth Abortion Ban Act, a copycat version of the law that had been struck down as unconstitutional in Nebraska 3 years earlier. It was challenged almost immediately by abortion rights advocates, including Planned Parenthood and Leroy Carhart. Because of the near-identical nature of the two pieces of legislation, several lower courts, including the Eighth Circuit, found the Partial Birth Abortion Ban Act unconstitutional, relying on the reasoning and the precedent established in Stenberg. When the Supreme Court agreed to review the case in 2006, it became clear it wanted to revisit Stenberg, if only to address the differences between states enacting specific abortion procedure bans and the federal government doing so. By this time, the court had become more conservative than the one that had ruled on Stenberg just a few years prior, primarily because Justice Sandra Day O'Connor had retired and been replaced by abortion foe Samuel Alito. With this change in its makeup, the new court made it clear it wanted an opportunity to revisit abortion rights, and the Bush administration's top lawyer, Alberto Gonzales, was going to make sure it had its chance. Justice Kennedy wrote the majority opinion in Gonzales v. Carhart, upholding the constitutionality of the partial birth ban and ruling that Dr. Carhart and Planned Parenthood had failed to show that Congress lacked authority to outlaw this specific abortion procedure. Abortion had once again become an area of federal concern. Despite the Supreme Court's increasing interest in limiting the power of the federal government, when it came to abortion, the conservative justices had no issue with Congress prohibiting specific medical procedures and dictating practices to doctors across the country. Furthermore, once again showing a willingness to defer to legislative assertions that intact D&D abortions were never needed to protect the health of a pregnant person, Kennedy also held that a health exception was unnecessary, correcting what the anti-abortion wing of the court perceived as the greatest flaw in the Stenberg decision. The court also determined that Congress was entitled to regulate in an area where the medical community has not reached a consensus, thus granting anti-abortion foes an opening to drive the evidence behind legislation targeting reproductive health care and choice. Most distressing of all, the court decided to assume for the purposes of this opinion that the principles of Roe v. Wade and Planned Parenthood v. Casey governed. In other words, the majority signaled that Roe and Casey were in effect for the moment. For court watchers everywhere, this was a visible and blatant signal to anti-abortion forces that Roe could be overturned in its entirety by the court if the right case were brought before it. Justice Kennedy wrote that he believed the lower courts had wrongly decided a central premise of Casey, and ruling that a pregnant person's right to choose abortion superseded a state's ability to place burdens on abortion in the interest of preserving fetal life. Since the federal ban fit that state interest, Kennedy wrote, it did not create an undue burden on the right to choose. Kennedy held that ethical and moral concerns, including an interest in fetal life, represented substantial state interests, which could be a basis for legislation at all times during pregnancy, not just after viability, as posited in Roe and limited in Casey. This effectively erased the pre-viability, post-viability distinction and rendered meaningless any previous understanding of how an undue burden on a right to choose would be measured. However, it was in its explanation of its abandonment of Stenberg where the conservative shift in the court became most apparent. The court held that the state statute at issue in Stenberg was more ambiguous than the later federal statute at issue in Carhart, despite the nearly identical language and findings supporting both laws. Most strikingly, the majority avoided all previous abortion case precedent by not analyzing the federal ban under a due process standard. Instead, they simply stated that the court disagreed with the conclusion of the Eighth Circuit that the federal statute conflicted with due process considerations, without explaining how it arrived at this conclusion. Justice Ruth Bader Ginsburg led the dissent, joined by Justices David Souter, John Paul Stevens, and Stephen Breyer. She argued passionately that the ruling was an alarming one that ignored Supreme Court abortion precedent and refused to take Casey and Stenberg seriously. Referring in particular to the court's holding in Casey, Ginsburg sought to reground the court's abortion jurisprudence in its previous acceptance of women's autonomy and equal citizenship, rather than the more nebulous and shifting previous approach centering around privacy. Thus, she wrote, legal challenges to undue restrictions on abortion procedures do not seek to vindicate some generalized notion of privacy. Rather, they center on a woman's autonomy to determine her life's course, and thus to enjoy equal citizenship stature. Due process cannot be ignored, according to Ginsburg, unless the court disregards women as full and equal citizens under the law. Ginsburg also took issue with the lack of a health exception in the federal ban, writing that the absence of a health exception burdens all women for whom it is relevant, women who, in the judgment of their doctors, require an intact D&E because other procedures would place their health at risk. In general, her dissent criticized the usurpation of medical decision-making by legislators and the minimization of the reasoned medical judgments of highly trained doctors as preferences motivated by mere convenience. While Justice Kennedy's majority opinion in Carhart did not explicitly overrule Roe or Casey, in her dissent Ginsburg made it clear that it might as well have. Casey's principles, confirming the continuing vitality of the essential holding of Roe, are merely assumed for the moment, rather than retained or reaffirmed. Ginsburg concluded by criticizing the majority for abandoning the principle of stare decisis, writing that a decision so at odds with our jurisprudence should not have staying power. But staying power is exactly what the Carhart decision had. By 2010, emboldened by an explicitly sympathetic Supreme Court, with John Roberts having replaced William Rehnquist as Chief Justice, while he joined with the anti-abortion wing of the court, Rehnquist had not been a judicial conservative the caliber of Roberts. Anti-abortion activists turned their attention to their next crusade: fetal pain. The Pain-Capable Unborn Child Protection Act, like many abortion restrictions, was created by anti-abortion activists and lawyers as a piece of model legislation that could be fed to friendly legislators to propose in local governments across the country, in particular conservative, abortion restriction-loving states in the Midwest and South. Written by lawyers from the National Right to Life Committee, the Pain-Capable Unborn Protection Act was considered the next logical step in fetal pain legislation, building off a 2003 Minnesota law that mandated that abortion providers must offer those seeking abortions the following statement: "Some experts have concluded the unborn child feels physical pain after 20 weeks of gestation. Other experts have concluded pain is felt later in gestational development. This issue may need further study." Further study was in fact done, with a 2005 article in the Journal of the American Medical Association concluding that, after reviewing multiple studies, evidence regarding the capacity for fetal pain is limited, but indicates that fetal perception of pain is unlikely before the third trimester. Despite this finding, Nebraska Speaker Mike Flood, one of the state's most actively anti-abortion senators, introduced the Pain-Capable Unborn Child Protection Act at the end of January of 2010, prioritizing a bill Nebraska Right to Life called their priority legislation for 2010. A young senator who had quickly made a name for himself as a politician to watch, Flood was named to Time magazine's 40 Under 40 list in 2010 as part of a new generation of civic leaders already at work trying to fix a broken system and restore faith in the process. Elected in 2004 from Norfolk, Nebraska, and becoming Speaker just 3 years later, Flood claimed that he wrote the pain-capable bill not to try to stoke a challenge to Roe, but to stop Dr. Leroy Carhart of Bellevue from becoming the region's main provider of late-term abortions. Mary Spalding Balch, the state legislative director for National Right to Life in Nebraska, was more blunt about the intentions of the bill. "I think National Right to Life wants to see something go to the Supreme Court that would provide more protection to the unborn child," she told the Omaha World Herald in February 2010. "What I would like to bring to the attention of the court is, there is another line. This new knowledge is something the court has not looked at before and should look at." Introduced on January 21, 2010, the Pain-Capable Unborn Protection Act was declared a priority bill on February 19th, allowing it to fast-track through the unicameral legislature. Senator Conrad, who became the face of opposition for the bill, filed numerous amendments to try to add exceptions for fetal anomaly and health of the pregnant person, all of which were defeated. Only one change to the ban ultimately made it through: an allowance for abortion in the case that the procedure could save the life of a surviving child in utero. This extremely narrow exception was created to address the testimony of Tiffany Campbell, a South Dakota woman who discovered late in her pregnancy that her fetuses suffered from a rare condition known as twin-to-twin transfusion syndrome. Fetuses with this syndrome are identical twins who, due to chromosomal issues, share a placenta with abnormal blood vessels that connect the umbilical cord and the shared circulatory system of the twins. It is a condition that, in its most severe cases, can kill both fetuses before birth. According to Campbell, one twin's heart was doing the work for both twins, and the effort of driving blood through both bodies was weakening him to the point where both would die. As her husband Chris explained to NPR in 2009, Brady's heart was doing all the work. He was pumping all the blood, and he was starting to show the effects of the strain, and he was really at severe risk of cardiac arrest. After meeting with several doctors, it was determined that the only option was to abort the second twin, allowing the first twin's heart to do less work and keep Tiffany out of danger, too. It was awful, Tiffany told reporters.
Sample complete. Ready to continue?